Hello, everyone. You're all very welcome to tonight's webinar. We're just going to give people a couple of seconds or a minute or so to get settled in. We have over 100 people registered for tonight's webinar, and I know not everybody is able to join us, but the session itself will be recorded and made available on our YouTube channels in the days ahead. And I know Niamh has also said that the slides themselves will be circulated to myself, and we'll include that in our email to you guys in the days ahead. So firstly, you're all very welcome, and we hope that you get a lot out of tonight's webinar. The particular focus is on wills and trusts and enduring powers of attorney. And this is a first for AsIAm in terms of hosting this as a webinar. We know that there's a particular demand out there to get information on these particular topics. So we're delighted to be joined by Niamh Maher and Emer Holohan, both practicing solicitors. Niamh is going to speak specifically on the topic of wills and trusts, and Emer will speak about EPOs in a little bit more detail. The presentations themselves should take around 35 to 40 minutes, and then we will jump into the Q&A session. Just to note that the Q&A session won't be recorded, and just another piece of housekeeping is that tonight's webinar, as in keeping with our previous webinars, is a legal information webinar, and it's not a legal advice webinar. So any of the questions that come into the Q&A box, please do include them in it, and I will then monitor those as they come in, and at the end I can put some of those questions to Niamh and Emer. So Niamh, I might hand over to yourself then if
Perfect.
that's okay, and then once you're finished then we will hand over to Emer. So thanks to you both for joining us on a lovely sunny evening in May.
Well, at least we're getting some sunshine. Okay, so tonight I'm going to talk to you about wills and trust planning. And basically, what I'm trying to do is guide you as best you possibly can. So when you actually go into your solicitors, you're armed with the knowledge as to what the correct structure is for you and your child or children when you're making your will, and in particular your trust will. And the aim is that when you do go in, that the document that you create doesn't lead you down the wrong path. And when I say lead you down the wrong path, the last thing you want to do is to create a will that is going to then affect your child's entitlement to certain state benefits in the future. So first of all, what is the difference between a will and a trust will? A will is the more straightforward of the two, in that you specifically give something on your debt. So the normal will is you go in, the standard will is usually for a husband and wife. Standard will is everything to each other and then to your children in equal shares. And then there's different variances of that depending on what your wishes are. So that would be, for example, the usual one: I give, devise, and bequeath 1/3 of my estate to my son for his own use and benefit. Absolutely. A trust will is different. So a trust will is a legal device that is created where you are basically giving your property on trust to another person to hold it on trust for the benefit of your child. So that would read something like: I give, devise, and bequeath all of my estate to my trustees upon trust for the benefit of my son X or my daughter Y. The reason that you would set up the discretionary trust is because if you just do the simple will where you give everything to your child is then at risk of losing state benefits like the disability payment. If you give it to them in trust, they are not actually legally holding it, so it's not legally in their name, so it won't trigger on a means test that they would lose certain entitlements. The most common type of trust that is set up is a discretionary trust. And this is basically a trust that gives your trustee broad powers. And I tell you why that is set up from a very practical perspective. Some parents would come into me and say, well, look, I want to set up a trust and I want to put very specific clauses in it as to what the person can and cannot do. And sometimes that works and sometimes it doesn't work, because when you make the will, circumstances may be of a certain way, but by the time you actually die, things may have moved on substantially, and the will and the restrictions that you have put in it can be sometimes completely and totally unworkable. So unlike other types of trusts, a discretionary trust gives a wide discretion to your trustee as to how the trust is to be used. This will allow the trustee over time to use their judgment and decide what is the best benefit of the money or the land that has been given under your will. And when I say use your judgment, so for example, it may be that your child has certain medical needs and monies need to be spent. It has given them the ability to say, okay, I think that this treatment needs to be done, and I'm using my discretion from the money in this estate that your child is going to get the benefit of that. Or it may be, for example, just say in your estate, you leave a property. It may be that property becomes unworkable, whether it is from a perspective that an access perspective, or if there's stairs that become unworkable, or that just a general upkeep of an old property is eating too much into the amount of funds that are in the estate. It may be that your trustee would actually say, well, look, this is unworkable. We should sell this property and buy a property that's more suitable to your child's needs. A discretionary trust tends to be very generally worded. So you're basically saying, I'm giving my estate on trust for the benefit of my child. Some parents would seek specific clauses. A usual one would be, I direct that my house will not be sold during the lifetime of my child. But then alongside that is usually what we would call letters of wishes. Now, letters of wishes are things that it is not legally binding. The only thing that is legally binding is your will. But a letter of wishes is usually a way of you saying to the person who is the trustee what I would envisage and what I would like for my child. So, and I'll go to them in a later slide as to what's usually included. That's just about the tax benefits. So the one major benefit of the discretionary trust for the child is that the state support, such as social welfare and other benefits, will not be affected. The financial support are means tested on the child, and as the child will have no legal ownership of the trust assets, they should not be affected. A discretionary trust can be set up in certain ways that there can be some tax benefits. I'm not a tax expert, and I would advise you all to get independent tax advice. It's actually very, very important because when you go and get tax advice, often people will come to me and say, look, I want it to be worded in this very particular way, and that will be to trigger certain tax benefits. The usual thing that we would come across is certain wording that might cause for a deferral of the capital acquisitions tax or exemptions from the discretionary trust tax. So who is your trustee and who is your guardian? So obviously the trustee is the person that you're handing the estate to for the benefit of your child or your children. I would say, and I would usually recommend in most circumstances, that your trustee and your guardian are the same person. The guardian is the person who on the day-to-day will basically take your place. So they will be living with your child and they will basically be stepping into your shoes. People will often say to me, well, look, I want X to be the trustee and Y to be the guardian. And what I would say from a very practical perspective, that often doesn't work. Because as you know, when you are with your child, there are certain expenses, and you can't expect the guardian to be ringing up the trustee and saying, can you release €300 to me for this medical expense that's coming up? So what I would say to parents is, obviously who you appoint, you want them to be good with your children, and you also want them to be good with dealing with the financial affairs. You don't want to appoint somebody as trustee who is not responsible with money and has made poor investment decisions in the past. We would also usually suggest, and it all depends on circumstances, but if possible, if you could have two people to be the trustee and guardian. It is often like a husband and wife, for example. It might be your brother it might be your sister. Like I have made a trust will for my children, and it's my sister and her husband. And the reason why you would have two is just, for example, just say I made my will and I never changed it, and my sister died before me. There is at least another trustee or guardian in place. The thing about wills is, I always say, make your will or your trust will as if you were going to die tomorrow. And that sounds pretty bleak, but the reason for it is if you keep trying to factor in what might happen in the future, you get to a point where you actually are not able to make the will because there's so many if, buts, and maybes. Your will can be updated at any time. And if you have one will in place, it's so much easier to update it. People often come back to me for small little changes. Or that they may decide that they want to keep this general structure in place, but they want to change who are the trustees or who the guardians are. So the letter of wishes is what I talked about earlier on. So this is not legally binding, and that's very important to understand. But it is a roadmap that you would give to your trustee and guardian as to what your wishes are for your child in the future. And I would say you should discuss, before you make the will, you should discuss certain things with your trustee and guardian. There are a lot of people say, I didn't ask them. You should always ask the person if they're comfortable with being the trustee or the guardian, because it may be that they say to you, I don't feel that I would be able to do that. And the last thing you want is a will or a trust will created. And then when you die, the people say, no, I don't want to take on that role. So always discuss it beforehand and discuss where your will is held and say to them, look, with the will, I have letters of wishes. I have the hospital passport, for example, and I have details of all my different assets, where my title deeds are held, where my bank accounts are held, and basically all your financial information. So what's included in your letters of wishes? The most obvious one is, for example, where you would like your child to live short-term or long-term. It may be that you would say, I want my child to move into your house, or it may be that if at all possible, I would like you to move into our existing house because that is obviously where my child is most comfortable, it is the most room. Your child's education needs and wishes. So if you would wish for your child to, for example, be in an ASD class or a special school placement, or to attend mainstream, and depending, obviously, it all depends on the age of your child. And then, sorry, the next one. The key people who are in your child's life, basically, and also what I would say to you in this is, this can be a document where you're giving them information. Remember, these people are going to be stepping into your shoes, and they may have very little idea as to what entitlements your child has. And so, for example, you could give details on the DCA, the carers allowance, the disability allowance, what your child is entitled to and what you are entitled to, because they will be stepping into your shoes, and what the process is to apply for those different things. What I would say about the letters of wishes, your letters of wishes should not be in conflict with your will, because if they are, the will stand, because these aren't legally binding. But if, for example, your will has a clause in it to say that the property that you die possessed of is not to be sold during your child's lifetime, and in your letter of wishes you're saying, look, I would like for you to sell the house and to use that to buy a different house, or I'd like the child to move in with you, and there's some like impracticality. So if you have a clause in your will where you're saying, I don't want that house to be sold until my child dies, but there isn't enough money in the estate for the upkeep of that house, that just may be completely and totally unworkable. So a bank account. So when you die, we take out a thing called a grant of probate. Now, grant of probates are taking a very long period of time to go through because there's backlogs at the moment in the probate office. And as the process starts, what happens is we write to all the different bank accounts and banks, and we detail the different bank accounts and the properties. The minute we write to them, they freeze the accounts. So from a very practical perspective, if your trustee and guardian is stepping into your shoes and everything has been frozen, they'll find themselves in the scenario that they're waiting for the grant of probate to come through before they have any access to funds. There are two ways around that. The first way is a joint account with the name of the trustee or guardian in it. The only thing about that is they will have access for withdrawals, but the most practical way is to open a special needs bank account for you and your child. And why that is really, really helpful is because when you die, your trustees will still be able to access that account. It's not subject to the grant of probate coming through. So it's an immediate access for funds. Funding a trust. So the big thing about that parents encounter is they'll say, well, look, I'll be saying, oh, well, what type of money have you put aside for your child's future? And they will say to me, well, it's a double-edged sword, Niamh. And the reason why it's a double-edged sword is obviously you're means tested. So any savings in your child's name is going to be mean tested when they apply either for the disability allowance, medical card, the travel. Any savings in the parent's name will be means tested when it comes to carers allowance, medical card, and it will have implications for the fair deal scheme. Obviously, if you ended up going into a nursing home, the amount that you have in savings is taken into account. I've seen online that a lot of parents have suggested putting a life policy in place, and the life policy in trust for your child, which is basically triggered when you die, and that the money goes directly into the trust, could be a solution around that. I'm not a broker, I don't know anything about it, but it may be something that may be worth exploring. Two takeaways, this is what I'm going to finish on. Two takeaways that I would say from this is, if you're setting up, if you're going in to make a will, the trust, discretionary trust, has two main benefits. Obviously, your big worry would be that your child will get immediate access to funds, and they may not be able to handle that amount of money and use it to its best cause and course. And the second thing is it will affect their entitlements. The discretionary trust is a way around that. And then the second thing I'm going to say to you is, before you make any will, you should get tax advice, because we will be guided on how we draft the will on the basis of the tax advice that you take. And then I'm going to hand you over to Emer, who'll talk about the EPOAs.
Good evening, folks, and thanks very much, Niamh, for going through all of that. And as Niamh said, Niamh is talking about people making a will. An enduring power of attorney could also be described as a living will. Now, the difficulty with this, I'm in practice for a long time, and I would have helped people over the years execute lots of enduring powers of attorney. But the powers that be in April 2023 brought in a new act, the Assisted Decision-Making Capacity Act. It was 2015, but it didn't come into operation until April 23. Now, prior to this, people could come into their solicitor, they could sit in front of us, just like Niamh said when they're making a will, and they could have set out what they want to happen if they became incapacitated. And that's what I said about a living will, that if you find that you are not able to carry out your wishes and you're not able to give instructions, you know, if you became incapacitated because of Alzheimer's or something like that. So you were able to execute them and put them in the safe in the solicitor's office, and a lot of the time they weren't utilised because people didn't need to take to use them. But if they became, or they suffered from Alzheimer's or dementia, weren't able to give instructions, we got a letter from a doctor to say they weren't able to give instructions, and then we went ahead and registered the EPA, and it became something similar to a grant of probate that Niamh spoke about. And the attorneys, which are sort of like a job with the trustees or the executors, they stepped into the shoes and they were able to carry out the wishes of the person involved and say, well, look, they wanted to be cared for at home for as long as possible. Or if they went to a nursing home, they could specify what nursing home they went to before they lost their ability to give instructions. But I can't talk about that anymore, folks, because that procedure and that way about getting advice from solicitors and solicitors talking through people what they wanted to be involved has changed now. And people, you have to do it yourselves. You have to go and log on to a portal through the decision support service. And it's difficult for people to do that. And I think it's when people are most vulnerable, when they want to make these hard decisions, and it's something that people like to do and then say, right, I've that done and draw a line under it. But at the moment, you have to do it. It has to be, it's a front loaded under a new system, and it's done through a portal. And the only people that have access to it is the person doing it themselves, the person that's making that's setting out the enduring power of attorney. And prior to this, they were giving people a power to manage their affairs in according with their wishes in the event that they lost capacity. And it gave them control and the ability to decide for themselves how they wanted their affairs managed. And it remained confidential between the person and their solicitor. And when they were bringing in this assisted decision-making act, and the establishment of the decision support service, that's how you do the portal. It was focused on the transition from wardship, and as I say, it came into operation in April 23. And the enduring power of attorney is created when the donor still has capacity, and that's important. You have to be able to give instructions. So I've had a few people that might come to me to say, listen, my mum or my dad, they've been diagnosed with Alzheimer's, they've been diagnosed with dementia, and they'd like to do an enduring power of attorney. And I'm sorry, folks, at that stage, it's too late. You have to have all your faculties in place and be able to give instructions in order to avail of this service. So now you have to go on to this portal, and you fill out all the details. And I think it's sort of disingenuous in the sense that you have to be tech savvy. And then if you're not, if the person that wants to make the enduring power of attorney isn't, they have to engage the services maybe of a child or a grandchild. And then they're showing their hand then, they're giving all their private details to this party that might be helping them to do this, to upload this information on this portal. I've had a few clients that have done it, and they've said that it is quite complex, and you have to have. One client recently told me that he did it in stages, that he did a bit, 1 week, and then he left it for a while and went back and did another bit. So the difficulty that solicitors have, and I'm sort of, talking about my profession, is that we could assist and help people with the previous procedure, but we can't now. We can't stand over somebody when they're inputting all those details, because they're doing it at home, they're doing it in front of their own PC, or they're getting help from somebody to do it. So there's no way that a solicitor can insist in that being set up. They can't review various options with the donor, the person making the enduring power of attorney. And you have to do it online. And a solicitor can't have an involvement or an oversight in terms of what documentation is reviewed or executed. And it's up to the donor just to do it all themselves. And it's in circumstances where the solicitor has no oversight or control, or indeed involvement in the creation process, and no way of verifying whether anything untoward has happened at that stage of the process. The EPA will have been prepared and executed outside of the solicitor's office, and they have no way of knowing who was present or who was involved at that stage. But the sting in the tail is that there is a part that has to be certified by solicitors. And if you talk to any solicitors at the moment, there's, look, I can't speak for every solicitor, but there is a blanket sort of refusal to execute this part of the form that they have to upload, because we haven't been involved in it from the start. Now, I would anticipate that there may be changes to it because there's been a lot of representations being done about it, and how over the years, your local solicitor has been able to help you, just as Niamh said, about your will and setting up your trust. But at the moment, we're not in a position to help people with an enduring power of attorney. And an enduring power of attorney is a very important thing to have in place.
Yeah.
And as I said, I did lots of them over the years, and a good few of them, people came back and said, listen, unfortunately, mum or dad can't make decisions themselves, and can we use this enduring power of attorney? And we did get it registered, and they were able to access bank accounts. But at the moment, you can, of course, do it through the portal, but there's not very many solicitors can be involved. Is that what you found, Niamh?
Yeah, no, it has changed from a system that was so straightforward to a really complicated system. So first of all, in order for somebody to get registered on the My Decision Making Services portal,
Yes.
they usually have to have a public service card. So a lot of them have to go and apply for a public service card first before they can do that. And then
And they have to have a mygov.ie account as well.
Exactly. Yeah. And then they do that. They are then basically asked a whole series of questions, which they do the yes and the no, like, do you want this person to be able to make decisions about your property, health decisions? And most people don't even know what they should be answering to it. It then creates 3 documents or 4 documents. One of the documents they have to go off to their GP and get signed to basically say that they have the capacity to make this document now. And the second document is the solicitors to basically say that they understand the implications of this document. And it's exactly as you said, there's an awful lot of resistance from solicitors to sign that document, because the Dublin Solicitors Bar Association have come out and said you shouldn't be signing those documents. And I think the Law Society are coming behind that as well, where they're saying, how can you stand over that this person understands it when you weren't involved in the process? I think the only way that it is actually working and is where solicitors are actually getting the client into the office and basically doing the computer
doing the whole portal themselves. Yeah.
And the whole thing about the EPOA is you create it when you have capacity and hope you never need it. It's then created, and it is only enforced in such circumstances where you lose capacity, and it can only be enforced then when a doctor certifies that you have lost capacity. So it's a document you create and hope you never need.
Yeah, that's what, and it just kept it, the old system, it was just kept with your will, and you were hoping that you never had to utilize it. But if you did, it was there. Now, as I say, the new system, you will be able to create an enduring power of attorney. It's just a lot more complex, and I think it's when people want to create an enduring power of attorney, that maybe they're vulnerable, that they feel they're getting on in years and they'd like to do it, and then suddenly, this thing is put in front of them, and it's like every step is quite difficult. You have to print out these forms, you have to bring them to the doctor, and then there's the difficulty with this form that a solicitor has to sign. And at the moment, I would say, Niamh, I'd say most solicitors don't.
They're not comfortable to sign it unless they've been involved in the process. So there's just backlogs. I'd say the number of people doing EPOAs has decreased dramatically since they brought in the changes. It's just not happening. And sorry, one thing that I didn't say on the will, people would often say to me, like, for example, they would be married and they would say, okay, well, what will happen here? Obviously, if you're married, your spouse is automatically a legal guardian. So usually the will would be everything to each other. And in the event of, for example, my husband predeceasing me, I direct that the following happens. And then that's when your trustee comes in for your child. Sorry, just to cover that off, because people don't think about it. What I would also say, the enduring power of attorney, if you're doing it, should also link in. It should be quite similar. So the usual person that is an attorney that you'd be appointing would usually be your husband or your wife. And then maybe also one of the trustees, if you have a trustee in your will as well. So all the documents should somewhat mirror one another, whether it's your letter of wishes, your trust will, and your EPOA.
I just wanted to mention something just on a nice sunny evening that we have, to bring in a little bit of humour. I had somebody recently making a will, and I asked about, they had young children, and I asked about a guardian and an executor and a trustee. And I said, look, it's usually the same two people that you appoint, because as Niamh said, you know, the jobs overlap and it's just easier. But this lady said to me, she said, well, my sister is fantastic with children and useless with money. So it was in that particular case, she appointed one person as a guardian and somebody else as a trustee, just because her poor sister wasn't great with money. So anyway, I just thought that was just to mention that, you know. But
Thanks for that, Emer, and thanks for that, Niamh. I'm going to stop the recording because we're going to go into the Q&A session now.